Welcome, everybody. I am Whitney Zatzkin, speaking on behalf of BIO-ISAC today. Thanks for joining us. We have a handful of guests. Quickly, we'll go around and say hello and introduce our groups, and then we will dig right in. There is a tiny bit of housekeeping, like every call you've been on for the last 4 years. There is a Q&A button down at the bottom corner or middle of your taskbar. For those of you logged in directly on Zoom, feel free to use that. I will monitor it for questions, concerns, and comments. You're also welcome to email help@isac.bio during the conversation if there's something more complicated that doesn't quite fit the Q&A portal itself. Beyond that, we will handle Q&A on our end and moderate it, just given the time and complexity of the content that we have to cover today. And with that, we'll dig in. Charles, you want to say hi to everybody, and then Evan and Lee can say hi.
Yeah, absolutely. Hi, everybody. Thanks, Whitney. I'm Charles Faraki. I'm the chairman and co-founder with Whitney of the BIO-ISAC. I think good to see so many friendly faces, and we're very grateful to the Department of Justice to be here today and sharing about the NAPRM. So that's it for me. I'll go on mute and turn off my video.
Thanks, Charles. Evan and Lee, you want to say hi?
Sure. Good morning, good afternoon, everyone. My name is Evan Sills. I'm one of the attorneys in the Foreign Investment Review section at the Department of Justice.
And good afternoon, Lee Licata. I'm the Deputy Section Chief for National Security Data Risk. I am the deputy responsible for implementing the executive order.
Wonderful. Thank you both. So quickly, you are here for a conversation about a bunch of activity that recently unfolded around bulk data sharing and use involving international transactions and transactions out of companies here in the United States. We have a brief agenda for today. I don't think it will shock anybody. We're going to go through introductions, check. We're going to give an overview of the executive order, provide a bit of context, and then chat through some work from Lee and Evan and the Department of Justice regarding an advance notice of proposed rulemaking. We'll then transition to Q&A. I do have copious amounts of links and things like that I will make sure to send to everybody in the aftermath. We do expect to have the recording of this available on our website for everyone as an information piece. As many of you know, responses to the advance notice are due on April 19th. And we want to make sure everybody has that link. Similarly, if you are a BIO-ISAC member, know that we are compiling submissions from our membership to be able to send those along to Lee and Evan and all of their colleagues at Department of Justice who need another report to read, I'm sure. And so with that, this all grew out of an executive order on bulk data sharing. And so Evan and Lee, I will turn things over to you and mute my line so that you can jump in and walk everyone through it. Obviously, having worked on it for the last year, you will do a much more sufficient job than I will do myself. So I'll hand it off to you all. Thank you.
Sounds great. Thanks so much, Whitney. Okay, so we are chatting today about the executive order that was issued on February 28th, 2024, fully titled Preventing Access to Americans' Bulk Sensitive Personal Data and United States Government-Related Data by Countries of Concern. I'm going to walk through kind of the key tenets of what the executive order requires the Department of Justice to go forward and do, and just highlight some of the key areas. So first, as you heard, so the kind of overall goal of this executive order is to not create a case-by-case review of data transactions, but instead create categorical, transparent, and predictable rules for engaging in certain transactions involving bulk-sensitive personal data. The regulations would prohibit or restrict categories of data transactions that pose an unacceptable risk of access by countries of concern or covered persons subject to their jurisdiction. The regulations would also exempt certain categories of transactions, such as financial services transactions, to allow normal commercial activity to continue. I will try and focus on the parts of this that are most relevant to you, but provide you kind of enough context to understand what the kind of overall goal of the executive order is. So first, the countries of concern. So we're considering identifying the same 6 countries that have been previously identified under similar authorities as the countries of concern, and those are China, Russia, Iran, North Korea, Cuba, and Venezuela. So the regulations that we're contemplating are only considering prohibiting or restricting transactions that involve those 6 countries. The categories would include entities that are headquartered in a country of concern, entities that are 50% or more owned by a covered person, anyone located in a country of concern, and certain subsets of country of concern citizens located in third countries. These would be defined categories of covered persons and would not include anyone who is a US citizen or anyone who's located in the United States. So to clarify for the public which individuals and entities are covered, we would supplement those categories by publishing a list of designated covered persons determined to be acting on behalf of countries of concern, like cutouts and proxies. So the list would not be exhaustive because persons and entities could still qualify as covered persons, even if they're not affirmatively designated, but we would attempt to make this as clear and transparent for everyone. Next, what kind of data are we talking about? So we plan to regulate 6 specific categories of sensitive personal data or government-related data. And these are precise geolocation data, biometric identifiers such as fingerprints and keyboard usage patterns, most relevant for you guys, human genomic data and potentially similar kinds of human biological data, personal health data, personal financial data, and specific types of covered personal identifiers. And those are the kind of the more traditional PII that you're familiar with, such as Social Security numbers. It would be limited to specific combinations of those types of data that can be linked to individuals, such as names linked to advertising IDs, to bank account numbers, to government ID numbers, or to hardware-based identifiers. We would exclude data sets consisting only of demographic and contact information that link together, such as names, addresses, and phone numbers. We think of this as the phone book exception. We are not trying to restrict data that's otherwise kind of generally available. We would also not regulate transactions that involve expressive information or personal communication, such as videos, images, or academic research. I will highlight the academic research part for all of you. Personal emails and other communications, or information that's already in the public record. The program would generally regulate transactions in these 6 categories of sensitive personal data only if they exceed prescribed bulk volumes. These bulk volumes would be set out in the initial regulations and would be defined in terms of the number of US persons or US devices implicated. Relevant for all of you, the genomic data is set rather low in the work, but what we're currently considering is in the tens or hundreds. Those bulk thresholds would not apply to transactions in government-related data. So there's kind of two sets of data. So there's the general data for all US citizens, and then the separate category of government-related data. The program would regulate categories of transactions involving sensitive data on US government personnel. And for the government data, it would be focused on sensitive personal data that's linked to current or recent former employees or contractors, former senior officials of the federal government, including the military. And for those, the regulation would be prohibited completely. So the bulk number for the purposes of government-related data would be 0. We're also contemplating prohibiting 2 categories of data transactions between US persons and countries of concern or covered persons. And those are specifically data brokerage transactions and genomic data transactions. Under the data brokerage prohibition, the regulations would prohibit US persons from selling, licensing access to, or engaging in similar commercial transactions involving the transfer of bulk sensitive personal data or government-related data to a country of concern or covered person. And then under the human genomic data prohibition, the regulations would prohibit US persons from engaging in transactions with a country of concern or covered person that involves the transfer of bulk human genomic data or biospecimens from which such data could be derived. In addition, we're also contemplating identifying 3 categories of restricted data transactions between US persons and countries of concern or covered persons. And these restricted data transactions will be allowed if the parties comply with security requirements that would be established by CISA, which is part of the Department of Homeland Security. And those 3 categories would be for vendor agreements, including cloud services, employment agreements, and investment agreements. So these security requirements would seek to mitigate the risk of access by countries of concern and would include cybersecurity measures such as physical and logical access controls and the use of privacy preserving technologies. So that is kind of the general overview of the program. Now, in addition to that, there would be a number of exemptions. So we're considering at least 5 categorical exemptions to minimize unintended effects on markets and businesses and to ensure that routine commercial activity can continue unimpeded. And these would be around issues related to financial activities, issues for multinational companies to share American sensitive data for ancillary business operations, like the sharing of personal identifiers for human resources and payroll, purchasing business permits or licenses, or sharing data with auditors and law firms for regulatory compliance. There would also be a carve-out for certain investments that don't convey rights or influence that ordinarily pose a risk of access to sensitive personal data, similar to the accepted transactions under the outbound investment ANPRM that's currently also going through the regulatory process. Additionally, there'd be a carve-out for data transactions required by federal law or authorized by international agreements, such as the exchange of passenger manifest information for international travel. There would also be a carve-out for activities of the federal government and its contractors, employees, and grantees, including federally funded health and research activities. If a transaction would, in addition to the kind of the prohibitions, and the restricted transactions and the exemptions, there would also be a licensing program. So the proposed EO would also require DOJ to establish processes to establish general and specific licenses and advisory opinions. In particular, specific licenses would give parties an opportunity to seek exceptions to the rules if their business is negatively affected. Licensing decisions would be made with the concurrence of other agencies as well, including the Departments of State, Commerce, and DHS. Parties would also be able to request advisory opinions and seek our guidance in the event that they had questions about their specific transaction as it relates to the proposed regulations. The next kind of component of the regulations is compliance. We're considering a compliance and enforcement program modeled on the one used by the Treasury's Office of Foreign Assets Control for sanctions programs. So U.S. firms would be expected to develop and implement risk-based compliance programs based on their individualized risk profiles. And lastly, a note on process. So the executive order came out at the end of February. We're currently in the, as Charles noted, the ANPRM section, where we kind of laid out what we're thinking and asked over 100 questions to all of you, the subject matter experts and those who live and breathe this work every day. And so we are seeking your input to make sure that we have narrowly tailored these proposed regulations so that when they are implemented in the coming months, they will be narrowly tailored. That means that currently nothing is in effect. So in terms of timeline, once the comment period for the ANPRM ends in mid-April, at which point we will review all of the comments and then issue an NPRM, a notice of proposed rulemaking later this summer, which will provide everybody with another opportunity to comment and provide feedback on the rules. And then eventually, we expect that the final rules will go into effect sometime early next year. So that is kind of an overview of the program. I will stop there, and we can continue this discussion.
Awesome, thank you, Evan. Lee, did you want to add anything?
No, the only thing I'll add is we're really looking forward to getting lots of comments on the record. That certainly helps us, as Evan said, get the right subject matter expertise to further refine what we're trying to build. And so, that April 19th deadline is really critical. And then again, in the NPRM phase, please consider writing comments for the record.
Well, and thank you for the overview of the process. As you were speaking, I was reminding myself, for those of you that haven't participated, the regulations.gov link provides you a spot to submit your comments. You are able to compose a PDF or a short letter, whatever format is something that you're comfortable communicating in. The important thing is to offer your expertise. And so as completely DC and inside the Beltway as a regulations proposed rule is, Please know I am here and available to help. All of us at BIO-ISAC have experience with these, and we can help your organization, group, or you yourself as an individual submit. It's a really important piece of public inquiry to find the subject matter experts and provide an opportunity for feedback and response. So please take the opportunity and the gift that it is to go to regulations.gov and jump in. That said, we do have a handful of questions. I know one off the top of everybody's minds, at least in the BIO-ISAC community, is one of security. And I know in private conversations, this proposed rule was focused on transactions. But I'd love to hand things over to you, Lee and Evan, and just reflect for a minute about the importance of cybersecurity as a backstop or a safety net in and through all of these transactions.
Yeah, absolutely. So when we talk about restricted transactions, that is the kind of key area where we're talking about kind of cybersecurity requirements, and CISA is going to be the ones providing those. So everyone who is already familiar with the cybersecurity framework and cyber performance goals and all of the metrics and standards that NIST and CISA frequently use will be used again. So what we're really talking about is standards for both the companies kind of overall that to have good access controls, to have kind of the basic cyber hygiene that comes with holding data securely in the first place. And then on the transaction piece, it's really using privacy preserving techniques that are going to ensure that when that data is sent across the transom, that it maintains its security. So we're talking about encryption, anonymization, all of those kinds of tools, and not any encryption or any anonymization, but ones that kind of meet CISA's standard.
And I'll just
Beautiful.
add,
Go ahead.
the CISA standards will be made publicly available probably just before our proposed rule comes out in late summer. So they'll be coming out through an RFI that CISA publishes so that the public has the opportunity to review and to provide input to that. But we thought it was important that the public have an opportunity both to see our proposed rule with the security standards at the same time to see how they all fit together.
Beautiful, thank you. Trisha, you had a great question in chat. If you don't mind, I'm actually going to turn on your mic so you can ask your question directly. Hopefully that worked.
Yeah, it did. Thank you so much. Yeah, I was just wondering, I'm thinking through the vastly different data governance policies that exist. Not, the US has one policy, other countries, the EU, GDPR, all these other countries have very different ways of handling data sharing and collaboration and things like that. And I'm just wondering if there is a plan for how to protect bulk data from the US once it has been shared with a partner country, and if there are any remarks you can make on that.
Sure. So it's a great question, it's one of those where if the United States was in charge of the whole world, it would be a lot simpler. But we do have somewhat limited jurisdiction. So I'll make a few points. One is the covered person piece that I discussed a little bit at the beginning is going to be one of the key points here, which is if you are in specific situations, which we will try and make as transparent as possible, if you are a country of concern citizen who works in a third country for, and we kind of, have significant concerns about that entity or the people working for that entity, it is possible that that we will address that concern through that process. But it really is going to come back to the U.S. company. So when the U.S. entity makes that data transaction, it's going to come down to kind of the U.S. company's ability to determine where that data is headed. And so as long as the U.S. company has no particular reason to believe that it's going to go to a country of concern, that is going to be generally sufficient. But if the transaction involves what we identify as basically a cutout for a country of concern that is in a third country, we will try and identify those to the best of our ability. And I will flag, if you know about those companies, feel free to send them to us and we can add them to the list.
And the only other thing I'll just add is that, as part of this effort, we've been engaged with our foreign partners quite significantly over the last few months, both before the EO was issued and since. I can tell you we've had probably almost a dozen conversations with the EU at this point because of, as you point out, the differences in sort of data governance policies. And we'll continue to have those engagements to try and bridge that gap a bit about what we're trying to do here and how we're implementing it. But that will be sort of an iterative process with our international partners.
And the only other thing I'll add, just because I think it's helpful context without taking you too far into the legal weeds, is these regulations are based on a law called the International Economic Emergency Powers Act, which is really a national security law. And so if this feels different from how Europe goes about these things, it's because it is, right? The EU comes at this from a fundamentally privacy standpoint, and the executive branch, can only operate under the laws that we have. And so, if you believe in that there should be a national privacy law, that is that is where you can call your congressman and and tell them this is truly a regulation under a national security law, and so we come at this from kind of the national security viewpoint, which is why it's limited to 6 countries of concern and not as many types of data as is covered under the GDPR.
Great, thank you. I know a handful of our folks hail from or partner heavily through academic research centers or other academic architectures. Could you talk a little bit to the protections that are expecting to be in place for that research to continue, and or the due diligence that you're seeing on the ground that our community could then respond to and offer comment? And then Charles, I'll swing to you for next question.
Sure. So as there are going to be a couple of exemptions that I think will be highly relevant. So one is it is an exemption for kind of things that are in the public record, and another exemption for expressive material, which covers lots of academic research. There's also an exemption for international agreements, and so if data is transacted through something that involves the World Health Organization or other kind of international agreements, that will be exempted. And the last thing I'll say is that we know that the Foreign Investment Review section at DOJ is not the subject matter expert here, and so where possible, we are working as close as we can with HHS and NIH, and and they will be responsible for their own contracts. And so, this regulation is really covering kind of what will apply to everybody. But if you have a specific contract with the government, that contract is going to govern as well. If you want to say anything like?
No, they covered it.
Great, Charles.
Yeah, absolutely. Thanks for that. So we also received questions around the notion of aggregating smaller volumes of data and how that could obviously cross a threshold, but any one transaction may not. What is sort of the risk management expectation that you have here, selling on the US side to potentially some of those countries of concern that fly below that? How are you thinking about resourcing the ability to even find out that information? And are there any also expected paths that comes with this regarding whistleblowing or any sort of enforcement information?
Yeah, all good questions. So I think the most relevant piece is that we will, even if an individual transaction is below the threshold, we will add them basically as many transactions as exists for a period of 12 months, right? And so for a year, in any 12-month period, if the number of transactions and the number of data in those transactions exceeds the threshold, that will be the bright red line at which we will consider it a bulk transaction. Beyond that,
There is some ability for us to go after transactions structured for circumvention. So to use like the money laundering analogy, right? When the Treasury sees a bunch of transactions for $9,999, right? We can still prosecute that as a means of circumvention. I think from an enforcement perspective, we'll have to look at whether transactions are being structured in a means to be evasive to these regulations. I was just about to the enforcement point, Charles, which is that, you're right, there is this challenge about how do we find out that transactions are being done this way. So a couple things is you'll see in the proposed rule a discussion of certain record keeping and reporting requirements. There will be certain circumstances that we will make companies either maintain records of certain transactions or to actually report them to us. That's one. The second, as Evan mentioned, that we're implementing this under IEPA, comes with things like subpoena authority, right? So we do have the ability to use certain types of enforcement tools, both criminal and civil, in order to kind of understand, where there might be evasion or circumvention. And then finally is, to the point Charles made about the tip line, right? The tip line is always open, right? We do have the ability to receive information from the industry if they suspect there's a bad actor who's not complying. We certainly welcome ways to engage to understand that information to determine if there's wrongdoing.
That's great, thanks. And I'm going to ask another one. Earlier this week, there was a conversation hosted by the National Academies around AI. And so naturally, there's a lot of anxiety in this space regarding embedded information in models, leakage capabilities through some of those models, which is obviously a very active area. Is this looking, will this approach also look at bulk data transfer through some of these models and some of those capabilities? And how do you anticipate potentially this not being as a transaction of records as they normally are seen, but rather potentially through the embedded nature or the possibility to extract that information from some of those tooling?
Yeah, so it's a great question, and I think we come at this kind of looking at all data equally, right? And so we are certainly aware that a lot of the data transactions, particularly going forward, are going to be used by AI learning models. But we from kind of where our office sits, we kind of look at it all equally. And so I would just say that we, whether it's embedded or whether for us it really is is a U.S. entity involved provided. So the regulation does consider it's not just the sale, it does include providing access to, providing a license for, right? And so if you are doing any of those things, so if it's truly open source and a public and available to the public, that's kind of a different situation. But if you are providing if it doesn't necessarily have to be a full sale of data, if you are providing a license, providing access to, that is all covered as well.
And I just add that, obviously the executive order authorizes the Attorney General to issue future rules, right? So to the extent we find a risk scenario that fits within the legal authority, we're happy to let the risk drive us to consider new rulemaking, right? This is the first one where we saw the highest priority risk that there was, consensus in the government that we should address. But I suspect once this program is set up, there will be contemplation of other areas of risk that we might need to address if we can, fit them within this legal authority.
Thank you. I think that's actually a great transition point, because I think in this conversation in particular, pausing for a minute, catching your breath, and kind of going back to introductions where you said, I'm Lee, I'm implementing the executive order. That's a really fun party trick. However, that's a lot of work and a lot of effort. And I think it's important to recognize that this is a first step in a conversation about all of our data and what's been happening, and confirming some of the risks, and codifying some solutions. 116 questions is a lot. What are the things that are most piercing for you that maybe almost feel like the most expertise is maybe needed to come together and help inform the work that you're doing?
Yeah, totally. I think we have, I think, a better, our expertise is on like how the regulate, how regulations should work, right? And so, we use other successful models in government as a reference. We, looked at, and the other place where I think, I would say, we have some amount of expertise is on the national security risk. And so we picked out particular types of data that, were most concerning to us and that we have seen bad actors try and acquire in the past, right? And so those are all the areas that we come to it with. Where we have less expertise is how it actually works in practice. So is data sold by the individual person? Is it sold by the 100? Is it sold by the million, right? And that's certainly different whether we're talking about genomic data or geolocation data. But what we are really hoping for is to hear from the private sector and the research community, about kind of how it works in practice and where they see gray areas, where they see, hey, this makes theoretical sense, but actually in practice, we're not sure that it's actually, that it actually works like this. And I will just, to the point earlier about submitting comments. This is not just to make me feel better. Comments can be positive and negative. So if you have critiques, that's great, and we want to hear them. If you think that the regulation is really good and is going to address a problem, there will be other people submitting comments who disagree with you. And so it is important for us to have both sides of the story so that we have the whole picture and not, only the people who find fault with something that we've done. So I will just flag that as well.
Yeah, and just to add to what Evan said, so there's three things that as you're thinking about comments that are really valuable to inform our understanding. And one, I think Evan suggested, which is the bulk thresholds, right? How is data sold? Those thresholds make some sort of sense, right? We looked at a lot of things that have already happened, transactions we've reviewed, breaches that have occurred, to kind of put some numbers around, at what point does a data set become concerning or present risk? But again, we kind of conducted that in a vacuum, right? So, match that up with real practice. What does a data set look like, and at what size is the haystack one that yields a really, risky needle? That's one. Two is the feasibility and efficacy of the security measures. I think, again, CIS is leveraging its expertise and existing standards to create a menu of options, but we want to know, one, what's doable for the community to actually deploy, and how well will they work, right? I mean, will they actually protect the underlying data set in these types of transactions or commercial relationships? And then three, which is the hardest one for us to get our head around, which is the sort of unintended economic consequences, right? Or unintended consequences. I think, it's, as the government, we don't necessarily have at our fingertips the kind of data that will make it easy to assess what this costs, right? And so part of the thing we have to do in a rulemaking is assess the cost and benefit. We certainly want to ensure that we are not, creating some second order economic impacts that we didn't intend, right? And so, Evan talked a bit about what's exempted from this to try and preserve the economic space, particularly with China. But I think we welcome input from the broader public about anything we've missed as we're thinking about economic assessment.
And on Lee's second point, I'll just add one more point, which is on this compliance and the security and the cybersecurity provisions. You guys can help yourselves by pointing us to standards and audits that you already use, right? And so we really don't want this to be any more burdensome than it has to be. And so if you say, ISO 27001 is really good and we already use it and it would meet all of your needs, then it's, we know it's much easier to show us a certificate than it is to do, a specialized audit on a new regulation, right? Like we are hoping to avoid that. And so, if you could, to the extent that you can point us and point CISA to things you're already doing that you think are, strong privacy preserving techniques, that is only going to help you guys in the long run.
That's a wonderful point. I think some of our conversations at BIO-ISAC, at least to date, have included what I always call the gentleman handshake of standards across cybersecurity. We have a lot of things that we've all said in a document are really nice and everyone should do it, but nobody seems to be doing it because we're all sort of awkwardly waiting and staring and hoping and crossing fingers. And so I think as a community, our intention is to highlight those things, put them into the submission for you to be able to review, many of which our partners have created those certificate programs. And I think for those of you that have not had the privilege of reading the 87 pages, there is a call out in the text for demonstrated due diligence and the intention to see that companies and academic institutions and all of those who are involved in a transaction around data sharing are at least trying to do right by whatever the final rule ends up being, and that those who are connected to the healthcare space will know that from HIPAA. Of course, when something does step out of boundary, there is consideration for the fact that the individuals involved were trying to do the right thing. So yeah, I'm not seeing Q&A or hands raised, so we may have traumatized everybody. Or I'm going to get a lot of emails in about an hour and a half as folks sort of get through all of their own personal notes on this. But thank you both for your time today. Charles, I would love to actually turn over to you. I know we wanted to reference a couple of convenings that we're working towards here at BIO-ISAC. I'll also share with everybody, we have a collaborative document that we are sharing internally at BIO-ISAC where folks can jump in and do very simple markup. And if there's some part of the text that you particularly want to highlight, but you won't be able to complete a submission of your own, I'm happy to field that and make sure that we consider it, review it, and include it in our comments as necessary. Evan and Lee, I'll give you a moment to wrap up before Charles officially jumps in. Thank you for throwing up the links. I did try to throw those into chat. I'm hoping that that chat meant that you could click on the links and actually pull them up. We had a little bit of a roller coaster with Zoom settings earlier today. So if you guys can't get the links, I'll try to make sure that I grab the attendee list and send it out over email. But anyway, Evan and Lee, final thoughts and reflections?
Yeah, just one more thing that the EO requires, which I think is relevant for you guys. There is a report that has to be written that we refer to as the OMIC report because, well, the initial regulation is focused on genomic data. We know that there's more to it than that, and you know, I think just as an example of the way that we are trying to think forward, and that there will be, you know, this is a first step and potentially not the last step when it comes to concerning types of data.
Yeah, and so to that end, you know, the other omics will be considered into the proposed rule as to whether anything else should be swept into the scope other than genomics, based upon that report that has to be issued within 120 days from when the EO was signed. And so we will use that to inform the thinking. I think you'll see in the proposed rule where that comes out. And then just to reiterate, you know, please file comments. And to the extent you have other clarifying questions in the meantime, please do not hesitate to reach out to us. We know this is a complicated subject, and we're happy to provide whatever clarity we can to inform your input.
Deeply appreciate it. Charles?
There we go. There's the button. So Evan Lee, thank you so much for spending the time. As we said, the links and resources are here on the screen. We'll send them along afterwards. But if you're interested in this topic, and in particular, if you're coming to the BIO-ISAC event, likelihood is you are interested in other activities that we're doing, particularly for those of you who are new, don't know what we are. We're a nonprofit that focuses on information sharing and analysis for the bioeconomy. We're specific to the bioeconomy, which is a broad area. But we have one event coming up in about a month, which I mentioned during my comments at National Academies earlier this week. I'll remind everybody here. We have a genomic data integrity event, which is going to be a working meeting in Huntsville, Alabama, in about a month. If you are interested to roll up your sleeves and contribute to a draft genomic data integrity standard that we hope to feed to the Department of Commerce and NIST in particular for consideration going forward in order to provide better security, better tools, better capabilities for vendors, practitioners, everybody alike, in order to simplify security and integrity of genomic data. It is only one of the omics, as Evan and Lee mentioned earlier, but this is the one that has the highest risk in our mind at the moment, and therefore the first focus. You can submit your request to join. We are curating the group that is coming. We are looking for people to roll up their sleeves and who have subject matter expertise in either handling genomic data, consuming it downstream, or having done large-scale sort of AI training on that data and some of the misuses that may happen there. So with that, I'll just close and thank everybody.
Wonderful. Thank you all. help@isac.bio. We are happy to field your questions and inquiries. I hope everyone has a wonderful weekend, and thank you for joining.
Thanks. Have a great day.
Bye-bye.
Thank you all. Bye.